Did you know that private conversation you're having with Claude and ChatGPT just might get you thrown in jail? Hey, do we even understand what privacy means now in the age of AI? And do your employees understand it? Hello, everyone. My name is Glen Guyton, workforce futurist and strategist, helping you to think strategically about the future. So, I saw this very interesting article come out about an exciting case that involves AI, fraud, and attorney client privilege. So, as we think about the future, AI is everywhere. Our employees are using it. I'm sure you're using it. Attorneys are using it. We're putting a lot of information into these generative AI tools like Perplexity, ChatGPT, Claude. So, what is the risk to you? This is what we need to be thinking about in this new age where we have this wonderful, fantastic tool. But there are some risks. So, let me give you a little background. There was a recent case that was just decided. So, this is hot off the presses, that was just decided against Bradley Hepner. So February 10th, 2026, I'll put the link to the case so you can read all about it. But basically, there was a person, he was accused of fraud, according to what I'm reading. And so in preparation of the law coming after Hepler, according to the reports, he decided to do some research using Claude to mount a legal defense. It's something we do, right? We put information in, we're trying to get information, and so we use these tools. So basically, hey, the police are coming after me. What do I need to do to mount a defense? Put that information in Claude, and guess what? The government seized that information, and basically the guy was found, it was indicted by the grand jury, and let's see, indicted for securities fraud, wire fraud, conspiracy to commit securities fraud, etc., making false statements to auditors, falsifying records, all this information. And part of the evidence used against him was the information that he put in Claude. And so his attorneys argued attorney-client privilege. And the judge said, no, that's not how it goes. AI is public information. This is not attorney-client privilege. So anything, just like, anything that you say can and will be used against you, well, anything you type into Claude, ChatGPT, Perplexity, according to this ruling, can and will be used against you in a court of law. And so the final verdict, his lawyers pushed against this, but the final verdict, I'll just kind of read that really quickly, says, generative artificial intelligence presents a new frontier in the ongoing dialogue between technology and the law. Time will tell how this advances, but AI's novelty does not mean that its use is not subject to long-standing legal principles such as governing the attorney-client privilege and the work product doctrine. So two very important pieces, the attorney-client privilege and work product doctrine. Now, key sentence, because Hepner's use of Claude fails to satisfy either of these rules, the AI documents do not merit the protection Hepner has claimed. So the government, I'm not a lawyer, but the government can use the information he put into Claude. They can seize it and use that as evidence to build their case. Wow, that's amazing, right? And so as we think about privacy, we think about data, information, what we're putting in these tools, it really changes what we need to think about as leaders. So there are a couple of considerations I want you all to be mindful of as we think about leadership in the AI era. Uh, and these are things that you need to communicate with your team. If you're using any form of generative AI in the workplace. Now, I know if you are maybe at a bank or working for an attorney, maybe you have these things locked down, but this is maybe for other people that aren't as savvy as you. But the first thing, perceived privacy is not the same as legal privacy. So all of that information that you are putting online is, in some sense, public domain. All right, that may not be the right phrasing, but that's how I want you to think about it. It's out there for the public. You may be thinking you're having a private one-on-one conversation with Claude or Chat, but you're not. This information is being recorded. So some of the things that you need to be mindful of, and some of it's common sense, but maybe we need to articulate these things a little bit more. So when we think about privacy, employees need to know that internal chats at work are not private. AI tools are not confidential, and digital conversations may not be protected. So what you're typing at work, the things you're sending between coworkers, if you're using Microsoft Teams, Copilot, these other tools, these conversations are not necessarily privileged in the same way that you have attorney-client privilege, or think that you have some assumption of privacy. I think this case is one of the first major decisions, or one of the major decisions that's going to shape how we operate when it comes to intellectual property and assumptions of privacy in the AI world. So leaders, you have to clarify what private means inside your organization, especially as we use more and more AI tools in the workplace. Another thing we have to understand, we are redefining, or at least these digital tools are redefining confidentiality. These third-party platforms, you really have to go and read all of the legalese right about them, what's allowed. But AI co-pilots, collaboration tools, cloud platforms, we're sharing more information than we realize. You think you're just sharing information maybe with a coworker, or you're just putting it on your system, but it's really broader than that. And so what do these new tools mean when it comes to communication? What's the risk that you have as an organization when you put your confidential data intentionally or accidentally on these platforms? And how can other people assess it? You know, there's been the question of not accessibility, but it's the algorithm learning, right? The algorithm learning from your data. So it may not be using it to get you thrown in jail, but it may be taking your intellectual property and teaching other people, using it to respond to other people. So how do we manage that? The third thing I will say, privacy risk is a leadership issue as well as a legal issue. All right. So we have to make sure that employees understand privacy boundaries in the age of artificial intelligence. Private information can be exposed quickly. It can be subpoenaed. We can lose trust because of, now we've had this issue with emails, right? We've lost trust with we've all probably unintentionally sent a wrong text message to somebody, or a wrong email, and we've tried to retract it, we couldn't. That hurts trust, right? Once people see these things, AI takes that to another level, or these AI tools, these AI chat tools, these generative AI tools can really expose some of our private conversations more broadly than we want. So leaders must actively think about these things, and how do we shape data usage? What are our AI usage guidelines in the workplace, and what are our clear communications about privacy? Even what do you monitor with your employees? They need to know. I think that's important for us to share that with our employees. What are we monitoring? What type of data are we taking and saving through our various tools? All right, so a few things, and let's use this as an example. A few things to think about. Think about just any kind of letter or information that we write now. Think about an employee posting internal strategy into an AI tool to improve wording. The employee may believe that, hey, this is private, but in reality, that data may be stored, processed, or learned from. All right. So when we're using these tools, even if it's like a spelling tool that helps us improve grammar, so these writing enhancement AI programs out there, if we're pasting information in there, understand that this information may not actually be private. You may be sharing this information beyond what you know. So your organization has to have some type of guardrails in order to protect sensitive information, especially if that information is proprietary. So you have to train people. You have to design the appropriate guardrails in your workplace. Again, that data that you think is private, or I'm just spell checking it, I'm just proofing it, I'm just rewriting it, I'm just rewording it using Claude. That data may be stored, processed, or learned from. So a few practical takeaways that I want you to consider. Questions that you can ask your team. Where might employees assume privacy that does not actually exist? Number 2, what tools are we using that introduce hidden exposure risk? And number 3, have you clearly defined what should never be entered into an AI system? Those are 3 practical things to think about, to consider as you lead teams in this new AI world. And we're always looking for signals, right? As a futurist, I'm always looking for signals about what's going to come, what's happening. The legal landscape is going to change. How we protect data. When do we open ourselves up to risk because we put our private information into this non-private algorithm? These are things we're going to have to consider. How do we protect our data? How do we protect our intellectual property? How do we train our employees to keep things confidential and private? So in a digital world, privacy is no longer defined by intention, but it's going to be defined by the systems we use and the assumptions we fail to challenge. Think about that. It's no longer about our intentions, but it's about the tools we use, how we're using those tools, and the assumptions that we fail to challenge. My name is Glen Guyton. You all have a wonderful, wonderful, wonderful day. And bonus piece of advice, if you have a legal case pending, talk to your attorney. Don't talk to Claude.